We're ready to officially kick things off now. And I'd like to ask Chief Justice Maureen O'Connor from the state of Ohio and State Court Administrator Lori Dudgeon to join me on the stage here. And as they're coming up and sitting down here, just a few words. The Conference of Chief Justices and the Conference of State Court Administrators, some of you may be familiar with CCJ and COSCA, are get together represented by all the Chief Justices from all of the states in the country and the State Court Administrator from each state in the country. CCJ and COSCA get together once a year for an annual conference in the summer, and then they meet separately at different times during the year. When they get together in the summer, they discuss issues that are of importance to the branch, and they take up business relative to their several separate associations. They get together outside of that annual meeting to work on projects that are of particular importance within the branch. They do that in a couple of different ways. They do that through the publication of white papers dealing with important topics like problem-solving courts and court security, domestic violence, continuity of operations, and court financing. They also get together from time to time, but it's been some time since they've gotten together to form a joint task force to look at issues of specific importance in the field. Chief Justice O'Connor and Lori Dudgeon are co-chairs of a recently created task force on fines, fees, and bail practices. And as we were putting together the conference content and thinking about the best message that we might share with our membership and hear from you all about, it was a pretty easy decision to make to ask Lori and Chief Justice O'Connor to join us to talk a little bit about this task force. Their bios are in your materials, and I was encouraged not to read them, and I won't. But you'll see as you look at their bios, and if you don't know them, you'll get the impression pretty quickly after we begin exchanging ideas and the conversation this morning that their experiences, their interests are impressive and highly relevant to this work. So with regard to this work, the situation in Ferguson, Missouri, which at this point we're all familiar with, and other courts around the country brought to light the issue of inequality in some jurisdiction of the manner in which fines, fees, and bail practices are practiced. News reports, other reports, white papers, and lawsuits have revealed that practices relating to the imposition and collection of fees, fines, and court costs excuse me, and the use of revenue generated from their imposition are not limited to Ferguson. Some of you may have seen the report that came out a little while ago about these issues that said that was titled, "This is not just a Ferguson problem." And there's a widespread sense at the highest level of the branch that in the states that policy changes may be needed and that practices can be improved. As a result, we have this joint task force. CCJ and COSCA established the task force earlier this year to address the ongoing impact that court fines and fees and bail practices have on communities, especially disadvantaged communities. The task force is comprised of national, judicial, and legal leaders, legal advocates, policy makers from state, county, and municipal governments, academics, and the public interest community. Much of the work is being supported by the State Justice Institute. We were together in March for a kickoff meeting. Work groups have been created. And that's what we're going to be discussing this morning. In the lead up to the session this morning and in conversations with Chief O'Connor and Lori, it became pretty clear to us pretty quickly that there was an acknowledgement on the part of our co-chairs that the voice of NACM was really important in this work. Mary McQueen from the center has referred to those of you who work on the front lines in the trial courts as first responders in this area. So the idea here this morning is to engage our co-chairs in a little bit of discussion about the background, the context, what the work plan is for the task force, but also to hear from all of you. So we've reserved a little bit of time at the end of the hour to do just that. We've got some microphones that we'll be walking around, but you also all will notice you've got index cards on your table. If issues come up that you want to make sure get in front of the task force, we ask you to fill those out, make sure that they're left on your table. We'll bring them up at the end of the session and we'll collect those. So with that, let me ask Chief Justice O'Connor, if you would, to give us a little bit of information about the background, where the idea for this task force came from and how it came to be.
Well, thank you, Scott. First of all, thank you for your participation in this forum this morning, and thank you all for being here and listening to what we have to say, because as Scott said, your participation, your involvement now and going forward with the implementation, we hope, of the improvements and the reforms that will come about is absolutely essential. And I can say that the Conference of Chief Justices discussed this matter in fall of 15 and then came together with the COSCA to form this task force in February of 2015, or 2016, this year. And the idea is that we will, as Scott said, bring together the entities that he mentioned and form working groups. And those working groups will divide their tasks into access to justice and fairness, transparency, governance, and structural reform, accountability, judicial performance, and qualification and oversight. So you might ask, why is this all necessary? Because not every community has a Ferguson situation on its hands. And I think that one of the things that we have to acknowledge is that while there are communities and court systems and cities within this country that are not in the same position that Ferguson found itself to be in, and the exposure that Ferguson had as a result of the incidences and the Department of Justice's intervention in Ferguson, I think it's become abundantly clear that there are situations, there are protocols, and there are occurrences within our country that mirror some of the worst parts of what goes on, or what had gone on in Ferguson, and that is the courts being viewed as a revenue generation center for the municipalities. And, you know, why is that a bad thing? Because I think the overarching problem that we have is lack of confidence in our courts. And when I say lack of confidence, lack of the feeling that everyone is treated equally in our court system. And whether that's true or not, it is the perception that matters, and it is the perception that we have to deal with. We have to recognize that there are certain standards that have to be applied to all people universally when they appear before the courts. And one of the things that becomes most daunting for individuals that come before the court is, what do they do when it comes to the fines and the fees that they have to pay, coupled with maybe restitution that is part of their sentence. And that is when the disparity is really evidenced in many, many court systems. You know, the situation first came about in a case out of Georgia, and it was back in 1983 on Bearden versus Georgia. And in that case, there was a gentleman who was convicted of theft offenses, and he was put on probation, and as a condition of probation, he had to pay $100 on the day of sentencing, $100 the next day, and then $550, I believe, about 4 months later. And he couldn't come up with the $450, even though he tried. He had been laid off from his job, and he had no resources from which to pay. So he was incarcerated because he could not pay that fine, and the part of it was restitution. And he went through the Georgia system and was denied relief, and then it came to the United States Supreme Court, and the Supreme Court said at that time that you cannot substitute incarceration for the civil penalty of failure to pay when the failure to pay is beyond the control of the person who has to pay. They have to, if they make a good faith effort, if they do not have the means to do so, they don't have the resources to do so, and I believe the case even mentioned about borrowing the money to do so, and if they cannot make that payment as a result, you have to have another alternative for them as opposed to incarceration. Now, we make it very clear that if there are resources to pay and someone willfully decides that they don't want to pay or won't pay, they won't cooperate, that's a totally different story. But we're talking about people who cannot pay, and not necessarily people who are indigent. And that's an important factor here, too. So with that background, the Bearden case, that sets the standards. And one of the things that the Bearden said was that you have to have a hearing to determine whether someone is willfully failing to pay their obligation as set by the court, or whether it is beyond their means and they cannot do so. Many of our courts have failed to have the Bearden hearings, and that is at the crux, I think, of the problems that have presented themselves. And that failure and that recognition that that oftentimes there is the inability to pay through no fault of the defendant, and the fact that they do not utilize alternative methods to impose upon the defendant, such as community service or some other means, and they go straight to an incarceration, and that is what is found to be a violation of the 14th Amendment.
Lori.
Well, and I just want to follow up. I think it's important. I'm curious, and just by show of hands, who in the room is seeing a Bearden hearing in your courts? Okay, and I'm really interested in the follow-up on which jurisdictions those are, so please add that to the note card. I want to stress that this isn't just a judicial branch problem. I think it's very, very important that we engage all the stakeholders, and that's represented in the membership on the advisory boards and each of the working groups. We recognize that it's a legislative issue and it's also an executive branch issue at both the state and local levels. So those stakeholders are engaged, and I think frequently what we see is legislation or local ordinances that require collections of additional fees. And I think this is happening in every jurisdiction in this room, and more than likely every jurisdiction across the country. We see these fines and fees levied to defray the operating costs of jails, to help fund our prosecutor's office, our public defender's offices, offset the cost of probation services, whether public or private. We see an assessment of late penalties, missed penalties, interest payments, all sorts of practices that I think that we're going to be evaluating through the work of this task force. I think several of us take court tools very seriously, and Court Tool 7, we all measure our performance based on Court Tool 7. We'll be taking a hard look at what Court Tool 7 says, and there will be some significant revisions I believe you'll see. We've got a lot. This project is expected, Chief, to last, we think potentially 2 years before we have a final report. But you'll see rolling deliverables from the advisory board. We are very interested in engaging NACM in your suggestions. We know that there are a lot of really good practices going on across the country. So we're right now, and actually Scott is a member of our advisory board, and he chairs the fourth working group, the steering committee, that's collecting a lot of the toolkits from across the country that we're going to present back to you as best practices. You know, Scott, I was struck by something you said when you're asking to bend the arc. And, you know, we're here today to introduce the topic, but I think very clearly we're asking you to help us bend the arc across the country with respect to this. Chief, you touched on the interest of public trust and confidence in the courts. And I think the last few years, this has really negatively impacted the confidence across the country.
I mentioned a few minutes ago that establishing a joint task force is not something that CCJ and COSCA do very often, and this is significant that CCJ and COSCA have done this on this issue. But both groups have been active already in talking about issues of access to justice and fairness and what have you. Lori, there are a couple of white papers that COSCA has done on this issue. That's right? Yes, we
first white paper in 2003, and then I think the second that courts are not revenue centers in 2008, and working on yet another white paper on the topic.
Yep.
And I might add that this is not just a problem for state courts' involvement and our solutions to help ourselves in overcoming the hurdle of the perception and also the reality. I have to emphasize that another entity that's involved with us is the Department of Justice. And the Department of Justice obviously was involved in Ferguson, Missouri, and the Department of Justice has been extremely active in this area. They were at the conference that, we had a conference in March of this year, and then there was a forum at the White House on this topic. They are going to follow up, I think, with another forum. I'm not exactly sure of the date of that. But in the meantime, they've also been very active in assessing and suggesting to communities individually what might or might not be, the appropriate action that they're taking. The Department of Justice, a lot of people think of the Department of Justice as a threat, that you don't want the Department of Justice to come into your community and scrutinize and then, have consent decrees and things like that. And that's absolutely true. That's the last thing you want. But the Department of Justice, I believe, can be, part of the solution and a willing and able partner with the COSCA and with the Conference of Chief Justices in this effort. And there's a constant line of communication, and they're as anxious and looking forward to solutions as we are.
Well, and it's been an opportunity, I think, for us to educate the Department of Justice in some areas as well. I think there was maybe perhaps some surprise that as state court systems, we didn't have complete control over all the courts. And I think that's an important thing to remember about the public trust and confidence aspect, is that what the word courts means to the public. They think we're just one entity. We're all the same, whether we're a local municipal court governed by your local fiscal court, or whether you're a general jurisdiction court or a superior court, or perhaps a municipal court like in Ohio that is under the governance of the Supreme Court. So it takes many different faces. We understand those differences, but the public doesn't. So I think it's very important that we educate. Scott, I realize I'm probably going off script here. I realize you, go ahead.
In our conversations and planning for the session, that issue of educating came up several times. And when we had conversations about the need to educate, the need to raise this issue as a priority matter, it often led into discussions about leadership. And what we talked about is what our intention is, not only at this conference generally, but at this session in particular, is to provide you and our community with information that would empower you to go back into your communities and to meet this issue head on and to address it where you find it. There is abundant information that's available, making clear that this is not just a Ferguson problem, that the problem exists. You may feel in your jurisdiction there's a need to do some assessment, some diagnosis, but there's also a compelling need in many jurisdictions to move forward. So with regard to that issue of leadership, Chief, from your perspective, in a state that's non-unified like Ohio, how do you see that playing out?
Well, I do think it has to be something that's recognized by the Supreme Court of each of your jurisdictions. I think leadership comes from your Chief Justice and from the Supreme Court. There has to be judicial education oftentimes, if not always. The Supreme Court, through judicial colleges and through the educational opportunities that they present for judges, this has to be a hot topic. It has to be something that is mentioned, studied, and there's extensive participation for judicial training. And I think that that's just the very minimum that needs to be done as far as leadership roles here. I think the various organizations that you belong to, NACM, and then your state organizations through clerk's offices and organizations or whatever you do have in your state, can embrace this as well and help to spread the word and to educate the membership about the, number one, that there is a problem. And that sometimes is the most difficult thing to do, is to have those that are in the position to change it to recognize that there is a problem. There has to be that first recognition. It's like any fault. If you don't recognize you have it, you don't work on a solution to fix it. So the educational component here from the judiciary and those in the court system that carry out all of the various facets of our court system, those that deal with the public. It's not the Chief Justice that's dealing with the public or the members of the Supreme Court or, for that matter, many of the judges, they do in the courtroom. But when it comes to interacting on a daily basis with the public that comes in, that are paying their fines, that are trying to ask questions, etc., there has to be a perception that is broadcast by those members of the court staff that they're in a place of fairness, that they're there to have their problems addressed, and that there are solutions to those problems. And we will work with you to help you to solve those problems. And I think that that's extremely important. You know, as I said, the recognition that there is a problem first. Now, the states are not going to wait for this task force to come up with recommendations and a paper, 2 years from now. I hope it's not going to take 2 years. I hope it's going to be quicker than that. But there are jurisdictions now, there are states and there are cities now that are being very, very proactive because they've recognized the problem. And I'd be interested if there is, membership here whose judges and court personnel and maybe local legislatures and mayors, et cetera, are currently addressing this either on the local level or the state level. Is there a show of hands where you're aware that it's happening in your states? Can you give me maybe shout out some of the states? Colorado? Okay. Good. Okay. Great. Well, I applaud you, and I applaud the judiciary in your jurisdictions for recognizing that there is a problem.
And we're pulling some of the resources from several of these states. Each of the work groups is looking at a lot of the work that's being done. And Chief, you mentioned the curriculum and the education. Our third work group on accountability, judicial performance, qualifications, and oversight will be taking on this and creating model curriculum, some communication material. These are the things that we want to deliver back to you. I think it's important. I heard someone say Washington. We've obviously taken a look at the bench cards that Washington has produced. Some of the rolling early deliverables that you'll see from us, I just wanted to say, was a model bench card on ability to pay. We'll also have the model ability to pay language for inclusion on motor vehicle citations. We're going to try to educate the public about this as well. Model language for registration of municipal and other limited jurisdictions courts. Model language for recording proceedings in limited jurisdiction courts. And then the Bearden infographic, I know that, Scott, your work group is about to have ready. So I just wanted to just give you some examples of some things that were coming. And a lot of these ideas are happening in your courts now that we've taken some of this and plan to adopt and try to get this information to everyone across the country.
And I might add that not just to pat Ohio on the back, but we do have a bench card that was developed by our judges who are in the municipal courts. Those are the courts that deal with the traffic and misdemeanor jurisdiction. And we have a wonderful bench card that was disseminated to all of our judiciary to explain the Bearden hearings that you have to have and the legalities of debt collection or fees and fines in Ohio. It's been really, really helpful. And I have to say, if I could just tell you a little bit about the background, this came about because the ACLU had received complaints in Ohio about some of the practices in our municipal courts. And the ACLU then contacted me, and we brought together a working group and rather quickly put together, and I do commend the judges and my staff who were on that working group, to put together a bench card to educate our municipal courts about the procedures that had to take place. And it was almost overnight that we addressed that problem, and we, naturally you're going to have a few stragglers that might not have read the card as thoroughly as they had to, and they were still creating a problem or two. And then, I have a very wonderful staff who intervened with those judges and re-educated them. And I can say now that I'm really confident that the members of our municipal judiciary in the state of Ohio are doing it right.
And so that's where it's happening right. Where it's happening right, or maybe where it's not happening right, is influenced significantly by custom and culture. And the advisory board has acknowledged that very specifically. It's been made explicit in our meetings and in our interactions that there are deeply rooted practices, philosophies, biases in play here. Lori, you work in a state where many people probably with us this morning know about Kentucky's Pretrial Release Program, which is a program that operates out of your office, at the State Court Administrator's office. An innovative program, a very successful program, but a program that takes a lot of care and feeding. Maybe you can talk a little bit about, from your perspective, what a big initiative like that, a lot of change, requires.
Well, our statewide pretrial program has certainly evolved, Scott. We originally started in 1976 with the creation of the Unified Article in Kentucky, and the pretrial system was born. Actually, it's a wonderful story. Julian Carroll was running for governor, and his primary opponent was funded by the bail bondsman's industry. So his first act as governor was abolishing bail bonding in Kentucky. So that's how the Kentucky pretrial system was born. And through that process, we have evolved, and with a lot of the research that is developed around the risk assessment tool in the mid-2000s, we began adopting and using a risk assessment tool to advise our judges on, obviously, risk of flight and risk to reoffend. And through a project with the Arnold Foundation 3 years ago, we developed the PSA Court, or the PSA Risk Assessment Tool, and I know several jurisdictions in this room are implementing the Arnold tool as well. There are a number of fantastic tools out there in which pretrial release decisions are based on things other than money. And we've seen several settlements through the ACLU, the DOJ, and the Southern Poverty Law Center, where several jurisdictions, the practices of the uniform bail schedule have been called into question as violating the Equal Protection Clause. So that is another, I think our first work group is tackling the bail issue and the issue on equal protection. But with respect to our pretrial program, what we see is release rates and a public safety rate that are greatly improved when compared to release rates under a bail system.
Chief, from your perspective.
If I might add to that, the problem with the bail system is the uniform bail amount per offense, and it doesn't take into consideration the circumstances of the defendant, the offender. And that is what is at the crux of the problem with a uniform bail, that there is no consideration of the repetitiveness, whether this is a first-time offender, what the circumstances, what the support in the community, et cetera. It's just if you committed a grand theft auto, this is what your bail's going to be. And that is what is inappropriate about bail. Not that bail per se is inappropriate, but it's the one-size-fits-all cookie-cutter approach to determining what bail should be. And what we're saying is that the judge has to take the time to assess the human being in front of him to determine what is the appropriate fit for that individual within the judicial or the justice system. And that sometimes is difficult for people who are making those decisions to grasp.
From a planning structural perspective, planning governance perspective, Chief, Ohio doesn't have a judicial council, that's right. But you use advisory committees and high-level committees to inform the court with regard.
We have a judicial conference.
Judicial conference.
Yes, that is all of the judges belong to the judicial conference, and they are an advisory group, and they're established by statute. They're funded by the state. Yes.
Okay. What do you see? What do you see as the, not only in Ohio, but thinking about conversations you might have with your peer chiefs from across the country? What would, suppose this is sort of a rhetorical question, what do you think about the need for engagement of judges and administrators should be, with regard to advising leadership in the states about what the needs are and what the way forward might look like?
And it's absolutely imperative that we hear that it's a two-way conversation. It's not just, the judicial conference or task force or special groups that we, advisory committees that we put together within our state. We do that quite frequently. It is a two-way street where they work on a problem, they work on, you know, what they perceive as, you know, a resolution. They bring that to the court. We take a look at it. There's an exchange of you know, questions and information. We talk about it on the court, and then we decide, you know, what recommendations that we can implement, what maybe needs a little more study. You'd be surprised that, you know, sometimes we have recommendations come from task forces or interest groups, and does not represent the entire judiciary. So we have, you know, feedback from those that are opposing. The judges don't speak and think with all one mind, and I know that that's a revolution to all of you, or a revelation to all of you. But as many judges, we have 720 some judges in the state of Ohio, and sometimes we can come up with what we think are great ideas and great initiatives, and we do get pushback. You know, from judges. We have, you know, each one of our judges is an independently elected office holder, from the chief all the way down to the municipal court, elected. And that plays a big part in how many of them look at their job, they look at their responsibilities, and they look at what they perceive the public expects of them.
I really like what you said about a two-way conversation, and part of what we shared with the chief and Lori, which is obviously already clear to them, is that you all are people in your courts, in your communities, in your jurisdictions who will be part of that voice. Lori, you talked about Court Tools 7, and if any of you have been to the Court Tools website and you look at there's a little announcement that was put up a couple of months ago. If you click on the Court Tools 7 tab, indicating that National Center research staff, with some input from the advisory group of the task force, is rethinking that. That's a critical component. Number 7 is a critical component of the suite of tools, and many of us already know that. Lori, you talked about it, and of course, it's many people in our audience here who have the responsibility for collecting, analyzing data, perhaps submitting it to the AOC, talking about it in their communities. Talk a little bit more about that, if you would, the importance of data. I know you guys the metrics that you guys have for your pretrial stuff is really impressive, but talk a little bit about the data piece, if you would.
Well, the data with respect to the auditing function on collections, or the data with respect to pretrial?
The former, to be sure, and then maybe the latter.
Okay. Well, first, I think with respect to the auditing function, we have to report every fee category that we collect across the state as a unified court system to our Finance and Administration Cabinet. So all the dollars that are collected on the local level are all remitted back to the general fund. So we have a significant amount of scrutiny over what we're collecting from both the executive and the legislative branches. And we're able to show through our accounts receivable program a completely automated accounts receivable program that marries to the case management system, what we're collecting and not collecting. So through the audit functions, we have never had, and I think this is going to be something, we've never had an ability to pay determination. We have a very complicated indigency form or informa pauperis form that what we find is happening as a matter of course, as in a lot of instances, our judges are waiving all the fines and fees as opposed on a determination of indigency. And our metrics, I'm just going to be honest, are not that great with respect to that on the first piece. Now, the data that we're collecting in our pretrial system is a completely different story. We have a case management system statewide for our pretrial, and then we have a lot of the data that comes from the jail data systems, and then also our case management system.
That's going to be a critical piece of this, and I think something that you all will be able to help us get our heads around, the task force that is, and particularly the work group that I'm working on. Chief O'Connor and Lori were very, very clear as we were planning for this session that they wanted to leave some time for some questions, but also some comments, particularly as it relates to things that are happening in your jurisdiction that may not have hit the radar of task force members. And so if you'd like, we'll pause for a moment now and just see if anyone has certainly a question, but also any news they want to share about innovative, responsive things that are being done in your jurisdiction. It's the kind of thing we'd like to hear about.
Don't be shy.
Oh, I see.
A little tricky in a plenary session. And if you could just say your name and where you're from. I know
I'm
you've
John
been-
Greason from New Mexico. I'll start this off. Chief and Lori, to what extent is your task force looking at public-private relationships in debt collection? The New Yorker ran an extensive article about a year ago about these contracted misdemeanor probation services in some southern states, where by contract with the court, a private entity was charging $10 a month for simply collecting fees owed or fines in a misdemeanor case. I know there are many reputable private sector debt collection services that we use, but it does seem to me that, particularly from the perspective of public trust and confidence in the courts, that the courts have an obligation to explore the practices of their private contractors in debt collection processes.
I thank you for the question. I think that's a great question. That is at the core of many of the citizens' distrust of their system. They are looking at very closely with that private probation, private, business operation. The problem in those situations is that the fees mount, so rapidly. And when someone comes in to pay, and maybe they're paying $50, oftentimes the majority of those dollars are gobbled up by fees that go to the private entity and not against the debt that they are, the fine or, that they're trying to diminish. And this has been the subject of litigation. The Southern Poverty Law Center has filed lawsuits with regards to specifically with regards to this practice. And I know that they've done it in Alabama, and I know that probably by now in other jurisdictions. So it's a problem. It's a recognized problem. And the entity that has to, curb that and control that has to be the courts. And that is part of the scrutiny of this task force, for sure.
And if I may add, John, good to see you. I wanted to just mention that this material is available online. The work plan, the projects tasked to each work group is all available on the NACM website, but that this is specifically, both of those two practices, John, that you mentioned, are specifically tasked to the first work group on access to justice and fairness to specifically make recommendations with respect to those practices. And I see a hand in the back. It just takes a minute for the microphone to get to the speaker. I am really curious when I asked the question about any jurisdictions having a Bearden-like hearing on ability to pay. We saw a few hands in the back of the room, like I want to say 5, and I would love to know what jurisdictions those are at some point in this conversation.
Good morning. My name is Lisa Howard. I'm from Texas, and I just wonder if you've been considering this building on New Mexico. We, in Texas, we collect state court costs, which make up a vast majority of the amount that defendants pay, and those are legislatively mandated. So that's kind of hard to work around those mandations when people are very indigent, they can't pay. So I just wondered if there was some consideration for those legislative changes.
And I'm, by legislative impositions, you're saying that the legislature says that we're going to tack on a fine, or excuse me, we're going to tack on a component to the fees for, I don't know, we have in Ohio the brain injury fund or something like that. That's what you're speaking of, right? Okay, she's not in her head. And oftentimes they will say that this is a non-waivable addition. Well, I haven't seen it litigated yet, but I would have I would be very interested if someone would come to the court and portray that as a separation of powers issue, for the legislature to tell a court that they cannot waive, in their judicial discretion, that particular component of the fine. I would like to see what a court would do with that. Now, I'm being very careful in phrasing that to tell you, so nobody would say, I know how Justice O'Connor would rule on that. But I would be very, very curious if anybody here has had that kind of litigation, and as a result, I don't think so, or we would have heard about it. But I do think that an argument could be made by the right attorneys that could be a separation of powers issue.
And to follow up just a little bit, we discussed this yesterday in our joint technology committee meeting, and it was actually David Slayton, your state court administrator, who made this point. I think we know that this issue with respect to the legislative function and the executive function will probably be one of the most difficult pieces of that. I think what it's important for courts to remember is that we are equally bound by the decision in Bearden, and that's that we can't jail someone for an inability to pay these costs. And I think that needs to be the thing that we always reflect back on. It has to be a willful refusal to pay. And because you're too poor to pay is not willful refusal and won't meet the Bearden standard. So.
And another component of that, if you just do the math, it is counterproductive to jail people because they cannot pay. It costs the communities and the justice system more to incarcerate on a daily basis an individual and have them work off their fine or however they term it because they're being incarcerated. That's not just an opinion, that's an absolute fact. And so I think that that's part of the argument that needs to be developed to discuss with the legislators and with the executive branches, both on the state and on the local level, so that they understand that it's counterproductive and their resources are being, just flushed away.
And the Brennan Center is doing some good work on this to follow Chief on the cost-benefit analysis of the efforts we're taking to collect these fines, fees, and costs, not just in the court system, but law enforcement, serving warrants, the additional staff time it takes to do this work toward collections. And
yeah, the commentary, the publications surrounding this issue are numerous, and I'm sure that many of you have seen these reports, and not only media reports, but papers and the scholarship that's being done in this area. Task Force is seeking to be a repository of all that information. But I'm glad you brought up, I'm glad we touched on this issue, because both of you work extensively with your colleagues, your partners at the state level in the legislature. Many of our members here, many folks here, work with county commissions and at the local level. And one of the things we really want to be tuned into is the kinds of information. You're right, Chief. It's an established fact. And I remember when we were in D.C. at the convening at DOJ, those events were very, very helpful. And we got briefed on research that had been done and was underway that I think is going to allow for the development of really clear and plain talking points as it relates to this area. But that's one of the things we're interested in on the green card, for example, is if you are someone in your jurisdiction who has the responsibility of meeting with your county commissioners, meeting with the folks in the legislative branch, what's the kind of information that would be helpful to you to help make the case, to reveal the urgency of these issues? And you're right, Lori, Bearden applies across the board. The fact that we don't see compliance with the principles means that we know that there's some education that needs to be done, And again, we're bumping up against issues of custom and culture.
I might add to the comments here that there has to be an open line of communications between the judiciary and local government, the city council, the county councils, the commissioners, whomever, whatever form that you have. And oftentimes that is not present. And that impedes a collaborative solution to this problem. And that might be a real cultural shift in your communities for judges to actually sit down with their funding organizations, their cities and your municipalities and your counties, et cetera, and talk about this sort of thing. A judge might not have any idea that it's counterproductive to put people in jail and the stress that's putting on the sheriff and the resources of the local community, because it's just not a conversation that has historically taken place. But with education and with some proactive urging, and I'm not saying that that you have to go home and you have to sit your judge down and you have to tell them exactly what's what. I know that that's an impossibility in many courts, but it should be a conversation that the kernels get planted, that you need to that there is a discussion, that there's a different way to analyze this problem. There is a smarter way to look at it, and there is a more progressive approach. And it's something, as I think we all agree, it's a cultural change. It truly is. There is very little sympathy for the defendants who have committed an offense, such as a theft offense or drug offense or whatever it is. For then the general public to say, well, geez, I really want to see them helped with their abilities to pay and et cetera. It's not a universally popular concept, but it is a legally correct concept that we're entrusted with enacting.
Scott, I'm not sure how much time we have. I don't want to forget to do something important, and that's thank Jonathan Mattiello again and the State Justice Institute for funding this project and the work of the task force.
Right.
The Department of Justice has issued a large grant solicitation that we expect will be awarded. The chief mentioned the next convening. I think the DOJ meeting is September 14th and 15th in Washington. Our next in-person task force meeting will be November the 14th and 15th. Scott, I'm not sure if we have any time for additional questions.
We do.
How we do?
We do.
Okay.
Any other questions or comments?
Hi, this is David Slayton, State Court Administrator in Texas. I just wanted to make a comment and then see if you could provide some information on the work you're doing. I think one of the things that I don't know for sure if the task force is looking at, but I think some of the colleagues here in the room would, especially our municipal court administrator colleagues, is looking at the structural issue of who the court administrators report to. I know this was an issue in Ferguson, and I know it's an issue in our state where some of the court administrators are reporting to the executive branch function, the finance director many times in our municipalities. That's a particular issue I think that ought to be looked at. And then I guess the question I had for you is, obviously there's been a lot of discussion about either pay or waive, but I was curious what the task force is looking at with regard to other alternatives to payment, and trying to expand those and make them more available to people as alternatives. So there is some still consequence to their offense, but not jail.
Well, let me address the first part of your question, and we do have that on the radar in the Transparency, Governance, and Structural Reform work group that will be looking at the independence of the judiciary and the independence of the court administrators in this scenario. What is the best practice there? Are they employees that are linked to the local government and possibly the police department or the sheriff's department, or are they answerable only to the courts, who would then hire them and provide for their responsibilities and their duties? There's an inherent conflict in many of the scenarios that now take place, and it would, obviously be our desire that there'll be a best practice that's identified, and see if that can help change that culture as well. Want to take the second half of the?
If I remember what the second half was.
Alternatives.
Yeah, the alternatives to the monetary, sanctions. Are there alternatives? Yes, I think that there are definitely alternatives. But we have to reshape how we look at those as well. And as Lori mentioned when we were discussing, prepping for this, oftentimes the work,
Community service alternatives.
community services that they have for them is done during work hours when they're going to their normal jobs, or so weekend opportunities have to be developed after work opportunities. Sometimes childcare is an issue. Is there a way that they can, address those issues as well? There has to be a way to make it work. And in order to do that, the locals have to think outside of the box, and there has to be a staggering of hours and a staggering of responsibilities.
And I know that our CTALK folks are in the room, and I think we've talked quite a bit about what the opportunities will be for some development on some pretty simple technology solutions to some of these problems as well. What I'm hoping is when we see the jurisdictions who receive these grant awards, that there'll be some dollars in there that would support some of that development on some of those projects.
We have just a few minutes left. So next steps in terms of, I know that CCJ and COSCA leadership will be meeting in a couple weeks for their annual meeting. Maybe talk just briefly about next steps, and then I'll wrap us up.
Okay.
Well, the next steps, we will be meeting at the end of July, and there'll be, a discussion to be presented to the chiefs and also to COSCA, as well as to, what we've done up to this point. As Lori mentioned, we do have another meeting in November. I'm going to be very interested to see what the DOJ meeting materializes and results from that, because that's before our meeting. But we do want to have deliverables that we can identify, and we'll talk about what they will be in July with the two groups, and then we'll see what can be accomplished at our November meeting. The bench card, for example, I know that's a work in progress. I've seen the draft for the bench card. I think it's off to a wonderful start, and that needs to be, modified somewhat. It'll be presented, and then we'll see if we can get an early stamp of approval on something like that. That's, I think, a huge step forward. I think that's a really positive thing, and people say, well, geez, I think is that really that powerful? And I know from experience that it is that powerful to give judges what the policies, what the law is, and what their practice should be, is something that's very, very helpful and helps them implement, which to me helps with a culture change, and that's important.
Lori, any final thoughts?
Well, and I think that we'll take interim reports from our working groups in November and consider an initial set of recommendations, as well as getting some material to you so you can begin sharing and introducing this concept. I know that this session, in addition to being live streamed, is taped as well. So I know that it's going to be available on the NACOM website. I think an opportunity for you to share it with anyone at home. Would encourage that.
Good idea.
Well, NACOM was invited early on to participate in the work of this body. We've got a NACOM representative on each of the work groups, and it was a no-brainer, as I said, to get Chief O'Connor and Lori here to talk to you all. And I'd be remiss if we didn't mention that the National Center is obviously deeply involved in supporting this work, and I think every member of their knowledge and information staff is assigned to one of the work groups. And then there are plenty of people from outside of that division or that unit who are also supporting the work. Tina Vigenis, who some of you may know, who is in the room, she's raising her hand back there. Tina is managing the project at the center. I think it's safe to say, we've got liftoff on this, and this won't be the last time that our members hear about this, and hopefully this has been helpful to you all in framing this up. Please, even if it's cryptic, write down what you want to make sure the task force considers on the note card. We'll make sure they get picked up. And with that, Chief Justice O'Connor and Lori Dudgeon, thanks very much for your time. We'll adjourn. See you at 11:45 for lunch back in this room.
Thank you.
Good job, Chief.
Likewise.
Good job.